All right, guys, we're back. Hopefully I've given you 10, 12 minutes to do that survey. So hopefully you've had a time to do it. If you don't, just go ahead and complete it as we start the class. All right, so the first thing we'll talk about is going to be any comments or questions with respect to the YouTube video I posted yesterday dealing with the Ecuadorian rainforest and the damage done by Texaco with respect to its oil exploration in Ecuador. Anybody have any comments to make about that particular video? Oh, Joy, your hand's up.
Yeah, so I was just going to make a comment about how that I just found it interesting that that video was from, a couple years ago and it was in Ecuador, but that it could be so applicable and to similar situations happening here in Canada, especially right now regarding the Coastal GasLink pipeline and issues regarding that. And then I just wanted to, I didn't know if you knew, but just sort of how that case ended up, because I sort of was trying to look into it and it was like they won and then it ended up being overturned. And so then they ended up losing in the end or something, if I have that correctly. So, yeah.
Yeah, thanks, Joy. Yeah, my understanding is that they didn't win. There was no reparations made by Texaco, so it is no better now than it was before. So, which is pretty disappointing because it's a horrendous impact upon those people, those poor people who live there. Kate, you had your hand up? Kate?
Hello?
Yep.
Okay. I found it really disturbing that there was like 15,000 coffin people and now there's around 400 left and that's it. And nothing's being like really done about it. Or well, no action has helped them.
Yeah, the thing I took from that is because it's so god awful in that rainforest. Like, why would the remaining 400 people stay there? I mean, clearly that's what's happened, right? Not everybody, has died. Everybody has moved away from it because it's so, I mean, your drinking water, your bathing water, the water you cook with, all has oil in it. I mean, so why would you stay there? Because look what it was doing to the children, the calcium deficiencies in their legs and their arms. I mean, my God. So yeah, I get that point. But my thoughts were, God, why would you even think about staying in that environment, other than the fact that, and this makes perfect sense, that they're so poor that they really have no other opportunities to go anywhere. But
that's what I thought.
Yeah, and that's absolutely true. Although clearly 90% of the population has moved somewhere else, so I presume they're luckier than the remaining 14 who stayed there.
Mm-hmm.
Lexine, your hands up.
Yeah, definitely. I found it really disturbing that the figures and the statistics, it showed that 4.3 million gallons of waste is dumped daily. And I'm like, what? And then they even compared it to US and they're saying it's 1,000 times more polluted than the oil dumps that are evident in the US. And I'm like, wow, that was really just disturbing.
Yeah, it was. It was absolutely shocking. The thing I took out about that as well, with respect to the topic for tonight's class, which is civil liability, which is why I gave you this video, is that as opposed to being in the U.S., these people are, they don't have any money. They don't have the means to properly, for instance, bring a class action and have it succeed. They don't have, obviously, any governmental environmental protections in place. Ecuador obviously doesn't care about it, or they would address it. So it's, when it comes to, often when it comes to reparations for this kind of damage, if the state, and we talked about this last class, doesn't have environmental protection laws in place, then it's up to the individuals to do it. And they just don't have that ability, as far as I can tell. Shivani?
Yes, I wanted to say it's very disheartening to see the living conditions that they're facing in Ecuador, where you could see the oil smudges and the oil spill. They have to bathe in it, use it for domestic purposes. And it's like, really dangerous. And, you know, we see that it causes a lot of illnesses. It even causes amnesia. So it causes damage to the brain. And we have to look at life in a way that we're very grateful to know that we're not living in certain living condition, because, you know, many people around the world, like, they're experiencing inhumane treatments.
Yeah, yeah. And the other thing, what that is, of course, is this Texaco, which is a multinational billion-dollar company, you know, clearly could not care less about the damage it does to the people in the area where they're drilling. You know, it's the fact that they would do that and continuously do it for 30 years, which is what the video was saying, astounds me, that they are such poor corporate citizens that they would cause that kind of damage. Aurette?
Yes, sir, definitely. I think what stood out to me in the video there is when that minister, I don't recall who he was, but he was saying that the Latin American countries can't afford to sacrifice economic development for ecology, the environment concern, and that says volume, because they're the one who should be taking the companies to task in fixing the environment. And it doesn't matter how much the locals do, they're limited in strength and resources. They can't fight these companies alone. And if the government already made their mind stand fast that they're not acting against these guys, the cause, the problem faced by those persons have already been lost. You know, they can't. There's no winning chance for them because their government has already bowed to the oil company in the name of economic growth. And I mean, there's not much, you're not seeing much growth either. So you can see the flip side of that, where all the natural resources, they're being reaped and being exported. The profit is getting exported. Nothing is going back to the local community. So I think that stood out more. That's something that stood out to me as I watched the video there.
Yeah, thanks, Red. I mean, the real shame about this is that, and we talked about this in the last class, there would have been no harm whatsoever in Ecuador having a robust system of environmental assessment in place. So if Texaco, you know, obviously they had their engineers determine that there was a large oil field there, you know, there would have been nothing that would have stopped Texaco from living up to an environmental assessment put in place by whether it's the state or the country, and they would have gladly, you know, put in place, you know, restrictions and ways to, you know, basically curtail the environmental harm for the purposes of being granted a license to in fact drill. And, you know, because it's a billion-dollar enterprise, they would have done whatever Ecuador asked them to do, you know, in order to get that license. But obviously Ecuador didn't care. Ecuador was more concerned about getting them in there, paying whatever fees they pay the country for the purposes of extraction, and with absolutely no regard for the residents. So it's pretty sad. Michelle?
I just don't understand how come the UN and Greenpeace and other global entities that are, you know, that go after people like this, that do environmental disasters like this. Like didn't they go after the Exxon people that had the oil spill in the Arctic? And I mean, I don't know, that was a while ago, but I mean, that is really sad. And they're polluting the rest of the world, and they're killing birds and the ocean and things like that. And they shouldn't. Like, I just don't understand how come nobody else is doing anything about it.
Well, the UN doesn't necessarily have jurisdiction over that kind of thing. The UN is there to a great degree to handle disputes between parties. So unless somebody is complaining, as in a neighboring country, you know, Venezuela, or somebody's complaining, then the UN's not going to get involved. You know, these people could potentially, I guess, try to take the country to the International Court of Justice. That's possible, but again, that involves a lot of money and hiring of lawyers and those kind of things, which they really don't have. So, you know, if there, you know, the problem is, and again, this is a function of the United Nations system where all these states are sovereign, except for whatever they agree to otherwise. You know, unless Ecuador has something in place to protect these people, then the people have no recourse against the country. So it's pretty sad. Tyler?
Hi. Yeah, that actually leads a little bit on to the question I had, and I mean, I guess that answers my question essentially. But my question was being, where would something like this be litigated? Who has jurisdiction over something like this? And is there anything that any rule that applies to a class action or a lawsuit like this, as far as the jurisdiction where the litigation would occur?
Well, yeah. So Ecuador, is a civil law jurisdiction. So it would have a superior court, just like we do, and a Supreme Court, like we do. So these people could have come together and put together a class action, get it certified, and proceed through the courts. That's certainly something that's available to them. But the problem, of course, is that they don't have the resources to fund something like that. But that's what they would do. They would sue Texaco in its operations in Ecuador. That's who the plaintiffs and the defendant would be. But again, litigation pursuing civil liability is a very expensive proposition. Danica, just hand up. Yes, no. Danica, Danielle. Yes, no. Does anybody else have any other comments or questions with respect to the video I sent you? I posted? We good? Shivani?
Oh, I was asking a question though.
Sure.
Because of the whole oil spill though, does it cause harm to like the fishes?
The marine life? Oh, absolutely.
Yeah, the marine life.
Sure. Oh, sure. It's Ecuador is on an ocean, right? So the rivers and streams and everything that have been polluted will flow to the oceans. Absolutely. Alright?
Yeah. So a question to you, sir. Seeing that the government is reluctant in holding the oil companies accountable, so there is no action that can be taken against those oil companies unless the government initiates it.
Either the government initiates it, or the people initiate it, and the government signs on to it.
So the government has to sign on to it for it to be acknowledged or move forward, right?
Well, except, and this is a response to Tyler's question, the people could, go through the civil system that's in the country, issue a class action without the government's endorsement to sue Texaco, who obviously is carrying on business in Ecuador, so it could be sued in Ecuador. But again, they need the money to do that.
But it wouldn't be fair to say if the government is not on board with those class actions, they won't go nowhere, right?
No, that's not true. Lots of class actions don't have government support, right? But it certainly helps, especially in a place like Ecuador.
Okay.
Danica?
Hi.
Hi.
Okay, so they said that they got a handful of rice each or something like that when this happened in 1970, right? And then they went to court or whatever and they lost. Did they get anything like compensation back instead of just rice, a handful of rice?
No, not that I know of.
Nothing?
No.
And then their employees get like amazing shelter and everything like that.
Oh yeah, absolutely. Including a brothel. So there you go.
Yeah, that's what I was going to bring up, the brothel. Yeah.
So yeah, you're working there. You're working for Texaco to take care of you. If you're living there and you're not part of Texaco's employment scheme, then you're dumped on, basically.
It's just sickening, but okay.
It was a very disturbing video.
Yeah.
Anybody else?
So Des, what's going on with Anika?
So Annika kind of resigned last week, right? She couldn't take the stress and
Was it all right? Was that a private conversation?
Yeah, it was accident.
No problem at all. All right. Shivani, your hand's still up, or is that from before?
Oh yeah, I was just asking though. What kind of government sit down and allow his people to be treated inhumanely though?
Third world countries.
Okay.
Third world countries who are poor, fundamentally poor, and who take whatever shortcut they can take in order to get some kind of economic activity going. A lot of countries, you know, some, well, not a lot, but a fair number of countries in South America are like that, Asia, Africa. There's a fair number of third world countries, you know, on the planet.
But it's sad though to show that money is more important than like human life, to be
Sure it
honest.
is. It's a disaster. It really is. It's a human disaster. Danica, is your hand still up? Pete, did you want to say something? Your name's up here.
Yes, I'd like to say something.
Sure.
I think this whole issue is dancing around genocide of the people. It's actually an ecological disaster there.
Yeah, that's a fair comment. Yeah, there's no question that what Texaco is doing is killing people. I don't disagree with you at all. Anybody else have their hands up? We good? All right, guys, again, thank you very much. Good participation. I appreciate it. Oh, Genwan, you want to say something?
So I just mention is the Singapore is a good example for the third world country, because for Singapore as a country, when from the third world country to a first world country, they spent 30 years, but they didn't really damage the environment. Is because they didn't focus on using build the industrial system. That's an example that for the other third world country could learn from them.
Sure.
Or we can just use in a small country, we cannot copy it.
Good.
Yeah.
Good example. Thank you.
And I have a question. It's like, is Singapore is an example for all the countries that we can learn, or just for the some of the small country they can start focus on some part of the economic development, not the whole industrial system development?
It's totally up to the will in Singapore. It's totally up to the will of the government.
I see. Okay, thank you, sir.
Yeah, absolutely. Any other questions, guys? Comments? Okay, thank you. All right, so I will now put up the PowerPoint. All right, guys, so tonight is civil liability for environmental harm. It's tonight and part of Thursday's class. All right, and then on Thursday as well, I want to talk to you guys about your group presentations to make sure everybody is getting prepared to submit them to me next week. Next week is our last week, so it's come and gone pretty quickly. But so we'll talk about that on Thursday. So, but let's talk about civil liability. So, civil liability is basically where private litigants. So, think about these people in Ecuador, where private litigants, you know, have significant obstacles in pursuing environmental claims. So, this is where, again, think Ecuador. This is where, you know, for instance, some entity, a factory or a resource developer or what have you, has done something that you know, wasn't part of an environmental assessment, perhaps, and or isn't subject to government regulation, depending on where they are. And so the damage done to the private citizens basically is something that they have to address by way of civil litigation, right? Which is going to be basically a tort, some kind of a tort, which is a wrong committed by somebody else. All right, and so private litigants face, you know, significant boundaries. They're evidentiary burdens, so you know they have to gather their evidence up in such a way that it's admissible in a court of law. Right? Again, I mentioned this with Ecuador. The cost of litigation is almost always horrendous. So unless you can get some kind of legal assistance on a pro bono basis, or potentially a contingency basis. Anybody know what a contingency basis is? So for instance, all the signs around town that say Feifel, Broadbent, and Galatsi personal injury lawyers, you know, you don't pay until we win. That's a contingency. It means that lawyers will take a case on on the premise that they will get a percentage of the damages awarded at the end of the case, right? And it doesn't cost the plaintiffs anything until you actually win. It's a lucrative area of law for lawyers to practice because contingency usually means 30 to 40%. So if somebody is, horribly injured in a car accident and they get $1 million for their damages, 300,000 to 400,000 of that goes to lawyers. So that's a pretty pricey law firm to have to pay. And the other thing, of course, is that these law firms don't take on cases unless they're absolute winners, right? They're not going to spend any time and their own money, because they spend their own money issuing the actions, getting the reports prepared, again, preparing the evidence for submissions to a court. The law firms, basically pay for that up front. They obviously get that back as a part of the contingency, but they only do it on a basically an all-win, no-lose proposition. So that's why, for instance, in Ecuador, there would be no guarantee of the people in the village of getting lawyers who would do a contingency basis, because there's certainly no guarantee that they'd win, right? Because of the court system in Ecuador, and it's certainly not a system like we have in North America, for instance. Anyway, and cost awards. So cost awards are, if you bring a lawsuit against somebody and you lose that lawsuit, you're going to have to pay a percentage of the other party's costs, meaning their lawyer's bill. So if you lose, not only do you not get any money, but you have to pay a chunk of the other side's legal bills. So, litigation is a difficult proposition at the best of times. So we're going to talk about tonight and next class, what I call the common law causes of action. So again, we're not talking about what we did a few weeks ago with respect to statutory or regulatory relief, right? We touched on all that. We're talking about the lawsuits that people have to bring individually if they think they've been done wrong, basically. So the first one we're going to talk about is nuisance. So nuisance is a very old and well-established tort, right? Which is a common law wrong. And what it basically does is it protects people whose use and enjoyment of their land has been interfered with by actions of other people, right? So if you're nuisance to your land, this is really relevant in the environmental context. If somebody has done something that affects your land adversely, environmentally, for instance, then, depending on how it happened, you may well have an action in nuisance against whoever did that to you, which is, for the most part, going to be your next door neighbor. There are two types of nuisance. One is private nuisance, and the other one is public. So I'm going to tell you what the distinction is between those two, right? So private nuisance protects people from the interference with the use, enjoyment, and comfort of their land, their own land. And public nuisance basically protects the public, right? Just not private citizens, but the public at large who have rights as citizens to, basically enjoy their citizenry rights, as they see fit. So the right of passage on public highways, right? That's a right that everybody has in common, or the right to be on, a canoe on a river or a boat on a lake, that kind of thing. So anybody who interferes with those kind of things is dealing with public nuisance, and we'll talk a little bit more about that in a few minutes. All right, so again, private nuisance, let's focus here. So again, a person's interest in the enjoyment of their land is protected by the torts of trespass to land, the rule of Rylands and Fletcher, which we talked about before, and I'll touch upon again, negligence, which we'll talk about tonight, and private nuisance. Okay. So private nuisance is applicable to what's considered to be indirect, not direct, but indirect physical or intangible, which is something that isn't physical, interference with their property, basically. And direct interference does not have to be physical, right? It's most frequently deals with things like noise and fumes and dust and smoke that emanate from your next door neighbor's lands, or could be further away if it's a really big nuisance, right? And it interferes with your use and enjoyment and the comfort of your own property. So if something is exceptionally noisy or fumes emanate on your property, there's dust and smoke, they all come onto your property, then that's a private nuisance, and clearly that interferes with the enjoyment of your property. However, private nuisance is not actionable, meaning you really aren't going to succeed. Right. All right. You need to turn your mic off. Okay. So private nuisance is not actionable, means you can't bring a lawsuit in private nuisance unless the interference with your enjoyment is substantial and unreasonable, and likewise you've suffered, in fact, some damage. Right. Okay. So liability doesn't necessarily depend upon the nature of the defendant, that's the person you sue, their conduct, or any proof of intention or negligence. You don't need this for nuisance, right? It depends primarily on the nature and extent of the interference with the enjoyment of your land by, caused to the plaintiff, being you if you're suing somebody else, right? It's important to realize that in most areas of the country, there is a boundary between rural areas and urban areas. And so there has to be, and the courts have done this at common law, develop a give and take between neighbors, right, who basically have to tolerate to a reasonable degree some potential interference with their property depending upon the use of their lands. So in 2013, the Supreme Court of Canada in Antrim Truck Center versus Ontario Transportation held that there were two distinct elements to the tort of private nuisance that must be analyzed sequentially, so that's one after the other. It must first be established that the interference is substantial, right? And then second, that the substantial interference must be an unreasonable interference with your use of your land, all right? So substantial and unreasonable, right? A substantial interference is defined as something that substantially alters the nature of your property or interferes to a significant degree the actual use of what you're putting your property to use for. Right? The reasonableness of the interference deals with basically a analysis of or examination of all the surrounding circumstances that gave rise to that interference. All right, so it's not open and shut by any means. So, the interference will take into account things like the character of the harm. We're going to talk about these in a few seconds. The character of the neighborhood, the intensity of the interference, the duration of it, the time of day and week, the zoning in place, the nature of the defendant's conduct, that's the person who causes the interference, and the utility of that conduct, as in, is the use that the defendant whatever they're doing that generates the interference, is it a kind of conduct that should be sanctioned and therefore not liable to be sued for? So in Antrim, the Supreme Court acknowledged that where there is significant and permanent harm caused by interference, the reasonable analysis may be very brief. Okay, so what that's basically saying is, if the harm is significant, right, then we don't really care about all those other things we just talked about regarding the scope of the interference, right? So it's likely that anything that causes physical harm to somebody's property as a function of a nuisance, there will be a finding in favor of the claimant. Okay. So here are the kinds of things that have actually, actually physical, that have been found to be a nuisance. Somebody has sued and been successful in these suits. So damage to the paintwork of somebody's building, which may be a function of something emanating onto somebody's walls that cause the paint to flake or damage. Damage to chattels on land, chattels being things that you place on your property caused by the discharge of pollutants, right? So it's environmental. Structural damage to premises caused by vibrations. So if your next door neighbor has a jackhammer going for an extended period of time and it causes structure to your foundation, then that'll result in damages. Crop damage caused by the drift of herbicide sprayed onto the property. All right, so this tends to happen more in rural areas, but that's certainly legitimate damages. Water damage to the basement of somebody's house caused by a blocked drain on your neighbor's property or even the city's property, right? That's actionable, okay? Damage caused by the escape of fire. So there's a fire next door and it comes onto your property and damages your property, right? That's a lawsuit. Damages to trees and shrubs caused by polluting fumes from defendants' factories. That at common law has found to be actionable as well. Right. So beyond the severity of the interference, we now talk about the circumstances giving rise to that interference. So things like the character of the neighborhood, right? So nuisance is a relative concept, depends upon the kind of neighborhood where the activity takes place, right? So this is important to realize that noise and smells that are tolerable in an industrial and commercial area may be excessive in a residential neighborhood. All right, so things that are nearby. So if the noise and smell that comes out of Algoma Steel somehow negatively impacts the houses that are close to it, right, then that's potentially actionable. I can tell you that I raised my wife and I raised our family on a farm, and while we had 4 acres and we had a lovely farmhouse, we were surrounded by farmland. Right, we were truly in the country. And so a couple times a year, when the neighboring farmers put the manure on the fields, right? If we went outside the house, you'd fall down dead. That's just all there was to it. So, and we accepted it as being a nuisance. It clearly was, that it certainly interfered with the enjoyment of our property. But with respect to the neighborhood we're in, which is a farming community, we had to accept it. We really wouldn't have been successful if we sued the neighboring farmers for the smell that emanated onto our property. All right. Okay, so the standard of tolerance may also be different in rural areas compared to urban environments. Right. So again, the difference between urban and a town. So this is kind of what I was talking about. The smells of some agricultural operations that would be reasonable in a rural environment, which was in our case, would be intolerable if those same smells were in town, and that's absolutely true. If you lived, in the city of Sault Ste. Marie in a neighborhood, a residential neighborhood, and you had the kind of smells that we lived with twice a year when the manure was put on the neighboring farms, it would have been actionable, because that's pretty much unreasonable in a concentrated urban area. Likewise, the reasonable level of noise in a city may be too much for a rural area. So the kind of noise you're used to in a city is not what you'd necessarily put up with if you lived in the country. There is no liability for the occasional loud noise, all right, or a transient bad smell. So, for instance, in our case, twice a year, that's pretty transient. If it was like twice a week, different story. The periodic barking of a dog, even though it's noise that may drive you crazy from time to time, as long as it's not all the time, then it's not going to be actionable. If it was all the time, that's a whole different story, okay? The smoke from a barbecue next door, that's pretty transient as well, so that's not going to be eligible for a lawsuit. The interference must be of a sufficient intensity to become intolerable to what's considered to be the ordinary or the reasonable Canadian citizens. So there's a reasonable objective test if somebody is sued for these kinds of interferences. The courts have basically decided that, for instance, for smells that amount to nuisance, they have to be described as things that are, for instance, nauseating, sickening, very offensive, and absolutely horrible. So that's what courts at common law have decided. Smells would have to rise to that level in order to be actionable. Again, the occasional loud party next door, the noise and dust from a construction site, the repair of residential roads, those are usually tolerable. Everybody accepts those as being, part of where you're living for the most part. That's a garage band. Some of you have heard this from parts of other lectures I've had. So a garage band in a residential neighborhood, is that going to be tolerable or not? Anybody? Somebody?
I guess it could matter on like how often they were playing and then how loudly the sound was, like kind of thing. Because potentially, so it could potentially, but those two things we just talked about, I feel like could come into question.
Excellent. Your name hasn't come. Who is this?
Oh, Joy. It's Joy.
Oh, Joy. Okay, thank you. Yeah, absolutely right. Joy is absolutely. So a garage band, teenagers playing in the garage, for the most part is going to be acceptable, even if you're next door to it, as long as it's, for the most part during the day, maybe a little bit into the evenings on the weekends, but certainly not at, 11 o'clock at night, any day of the week, or, maybe even 5 o'clock on a Sunday afternoon, that kind of thing. And how loud it is. But it's tolerable up to a point, but when it gets to the past that point of being tolerable, as in it really does significantly affect the enjoyment of your property, then it's a whole different ballgame, right? It becomes something that can't continue. So when the interference persistent and long-term, what becomes tolerable now becomes intolerable, basically. The time of day when the interference takes place is relevant to the acceptable level of noise. So in a residential area, it's reasonable to expect less noise at night than during the day. That just kind of makes sense. This is common sense. The day of the week is relevant, right? So courts have looked at if somebody is trying to sleep late on a weekend, right? As opposed to during the day when during the week people go to work. That seemed to be sometimes intolerable when during the week would not be intolerable, would be tolerable. So that's important. It used to be more important, this particular argument, when Sunday, and you guys are too young for this, but Sundays used to be closed for business, right? And it's only been 20, 30 years that Sundays are totally open. But we had what's called the Lord's Day Act, and it was in place across Canada and most Western democracies because we are fundamentally a Christian, not fundamental Christians, but we are a Christian society. And the Lord's Day Act was put in place that basically said that nobody can work on the Lord's Day, which is Sunday. If you're Jewish, it's Saturday, but again, we're a Christian society. And so, there's a lot of restrictions upon doing any number of things on Sundays. So a lot of things that would have been perfectly acceptable from Monday to Saturday were not acceptable on Sunday. So, and in fact, were crimes. If you did something that contravened the Lord's Day Act, it would be an offense, right? That's now gone by the wayside, but that gives you an idea on how important sometimes the days of the week are. Defendants can sometimes defend any action for nuisance based upon the fact that what they are doing is generally beneficial to the public, right? So that's potentially a defense. And so the utility of the defendant's conduct, as in how useful is it to the public, will weigh more heavily in favor of the defendant if the defendant is a government or public authority acting for the greater good of the community, right? So you would have a pretty hard time if the interference with your property was taking place by a government body who basically is paid for by the taxpayers and doing something for the public at large. That would be a tough lawsuit to win. So the most common forms of private nuisance are ones, again, that emanates from the defendant's lands, which maybe your neighbors are a little further out, crosses the boundary of your property, intrudes onto your land, and causes damage or a loss of enjoyment. So that's a pretty good synopsis of what's involved. So noise, smoke, water, fumes, chemicals, odors take this form. Not all nuisances fall into those categories, but those are the fundamental categories. There are very few circumstances where physical damage to property can be inflicted without some intrusion. So the case that I refer you to, again, is from Canada, Pujalese versus Canada National Capital Commission, which was in Ottawa. So in that particular case, the defendant's construction of a sewer collector, right, done by the National Capital Commission, lowered the water table under the plaintiff's land, so it didn't cross over it, it didn't emanate over it, kind of thing. But what it did is it took away the substructure of the land, the plaintiff's lands, which caused it to subside, which obviously in turn caused damage to the houses under which the sewer lowered the water table, right? So that was a nuisance. So the defendant was held liable. Again, the nuisance was held basically, the National Capital Commission was held liable, right, for the damage, even though it was the removal of water under property rather than the invasion of water onto somebody's property. So that's a distinction, right? However, there is no liability, for instance, for things like blocking the plaintiff's view. So if as long as you comply with the zoning bylaws that are in place, if you had a front yard that had a lovely view across the street of a stream or a forest or what have you, and somebody built something in front of you between you and that forest or stream, right? That's not going to be a liability as long as, again, it meets zoning regulations, even though that truly does interfere with the enjoyment of your property. or, you know, somebody built something that prevented sunlight coming onto your land. So they built something, you know, 1 or 2 stories higher than your property, and it was in such a place, it was south of your property, so that the sun wouldn't come on to your property as it used to. That's not going to be found to be a nuisance, although clearly it does interfere with your enjoyment, right? A neighbor's property may be extremely ugly next door to you because of general disrepair, or because you don't like the architecture or the color, right? So if somebody paints the house next door to you yellow, unless of course you like yellow, but I mean, usually that's a pretty offensive, you know, color to have next door to you, or bright purple or what have you. Arette, you raised your hand?
Yes, sir.
Sure.
A quick question. So in this case, right, this is a real situation that's ongoing. So a neighbor has his wood stove in his garage, and he burns it a lot, and the smoke comes out and blows onto the other neighbor's house, where you have kids in the back jumping and trampoline and clothes hanging on the line, right? And those clothes become soaked in the smoke. And those 2 neighbors have been going at it for a bit. Would that be considered as a nuisance activity?
Well, absolutely. As, you know, not only the smoke itself, but, you know, if it, as I said, if it's causing damage to the laundry on the line kind of thing, the smoke's going there and physically doing damage, then there's not a lot of question that that's a nuisance.
But in the event where that person has no control over where the wind blows, and he has a legitimate reason to be having the his wood fire thing going, if he so desires.
It's still a substantial interference with the neighbor's enjoyment.
Oh.
Ariana, do you have your hand up? No. Shivani?
No, I don't have my hand up.
Okay, just the name came up. That's fine. All right, guys. So anyway, yeah. So even things like, and I just did this as a joke, but it's, you know, even things that are so ugly that it drives you crazy. For instance, your neighbor's lawn is this, right? That's not actionable, right? You know, they can do whatever they want. You know, and as silly as it may look, and maybe it drives you crazy when you come up your driveway every day to see, you know, a lawn full of these things. That's not actionable. Okay. Some non-intrusive interferences, however, are still actionable, right? And they basically come into the realm of the defenses that are available for nuisance. So there are 4 main defenses to an action: statutory authorization, statutory immunity, consent, and what's called prescription. All right. So for the purposes of statutory authority as a defense, the defendant, that's the person who has been sued, must prove that it was practically impossible to avoid creating nuisance. So Arette, maybe this is what you're talking about. If the neighbor who is, you know, has the wood stove in the garage, if the neighbor, you know, basically is saying it's impossible for there not to be smoke emanating from this. All right. So that's a possible defense, but again, it involves in the level, it's an analysis of the level of interference and the substantiability of the intensity of it, right? A nuisance, in order to be basically eligible for this defense, must be shown to be inevitable and the unavoidable result of authorized activity. Right. So again, you know, the stove in the garage, the argument would be from the person who has the stove that the smoke emanating from the chimney for the wood stove, it's unavoidable that it's going to go next door, right? And having a wood stove in the garage is an authorized activity, as in the city of Sault Ste. Marie has no problem with it operating in the garage. All right, so it becomes a little more complicated. Statutory immunity, basically provincial legislatures, because again, this is a provincial responsibility, have selected certain kinds of beneficial land uses for immunity from the tort of private nuisance. So this is something that the Queen's Park has put into place by virtue of a statute, right? So legislation has been prompted largely by things like, again, we talked about this, the conflict between agricultural operations in rural areas and expanding urban communities. So legislation can go in place to protect those kind of uses, right? So an agricultural operation that complies with normal farm practices and is, basically authorized as a function of land use control bylaws. We touched on that last day, municipal use of a property, can't be liable for nuisance for odor, dust, dirt, smoke, or any similar disturbance, right? But that's only in those municipalities that, or only in those areas of the province where it's been enacted that this kind of use is protected from nuisance. All right, the remedies that are available for nuisance, there are two fundamental remedies. The most common remedy is an injunction. Anybody want to give me a quick definition of an injunction?
So basically, like when the government or they give they tell you to stop doing what you're doing basically. So you have to, if you're doing something, you just basically stop.
All right, and Tyler, you put your hand up.
Yes, it's a court order that requires somebody either to do something or to refrain from doing something.
Exactly. So you're both right. So it is, government is a court. If you think that somebody is causing you substantial interference with the enjoyment of your property, and therefore you think that you have a cause of action at common law for a private nuisance, then you would go to court, and the first thing you would ask for is an injunction to stop that from going on. So in Aurette's case, the neighbor whose laundry is being damaged and whose kids are being smoked out when they enjoy the backyard, right? That neighbor, the first thing they would do is sue the neighbor next door, go to court and get a court to hopefully issue an injunction saying, stop using that wood burning stove, at least in the way you're using it, so that it stops, basically emanating smoke next door, right? Damages are also available, basically, and are there if there has been basically something that has physically caused harm. Usually it's a single event like fire or water damage, right? So not only do you want to stop whatever has caused the damage by way of an injunction, but if it was a one-time thing, a fire or water damage, that you don't have to stop going forward because it doesn't take place any longer, but it did cause a lot of damage, in a one-off kind of thing, then you're going to want damages to repair your property to the point where it's to the point where it's in the same state it would have been if the damage by the fire or water hadn't taken place. Okay. All right, guys. Now, public nuisance. So remember, we talked about two kinds of nuisance. So public nuisance is not primarily a tort concept. It's more like a quasi-criminal kind of concept, basically. So it's a resort for charges being laid against anybody who is causing the enjoyment of public property and interfering in that way. Obviously, these are things that are determined by the Attorney General in each province, right? But it can have what are called tort consequences, because if it causes individual damage to people, then damages can be awarded apart from being charged with whatever's been done. The common law definition of a public nuisance is now pretty much in the criminal code, which is called, in fact, a common nuisance. So section 180 sub 2, the criminal code states the following: everyone who commits a common nuisance, who does an unlawful act or fails to discharge a legal duty and thereby A, endangers the lives, safety, health, property, or comfort of the public, or B, obstructs the public in the exercise or enjoyment of any right that is common to all the subjects of Her Majesty in Canada, is subject to conviction under this section. All right, so that's clearly a common nuisance. Public nuisances also fall into two broader categories. The first includes interferences with rights and interests of the public, which all persons share in common, right? And again, we talked about this before, things like obstructing a public highway with a stalled motor vehicle, setting up barriers on public property, protest marches. So, think about this past winter with all of the public protests that were given rise as a function of the claim by the Wet'suwet'en hereditary chiefs in Alberta, who basically wanted to stop the light natural gas pipeline. They stopped the RCMP and the public highway from coming into their lands in Alberta, and the Mohawk, for instance, in Ontario, blocked certain aspects to the 401 highway outside of Kingston, right? Those were, apart from, certainly having a criminal element to them, were public nuisances, right? They stopped the passage over public ways for people to go on highways, what have you. Excavations or heavy smoke, blocking access to a public park is a nuisance. Blocking a waterway, so somehow or other stopping a stream or river or whatever it is, or even parts of a lake from people navigating them, then those are public nuisances and subject to conviction under Section 180. Polluting the air with smoke and fumes, obstructing a public sidewalk with temporary structures, demonstrators or lineups of people, and running a body house. So this is very interesting. So a body house is a very old anachronistic term. It refers to, for the most part, a brothel. Doesn't have to be a big brothel. It can be a room with just one person carrying on sex work, but that's called a body house. So it's not B-O-D-Y, it's B-A-W-D-Y. And even though prostitution is a totally legal enterprise in Canada, always has been, it's never been a crime to be paid for sex work. The carrying on of prostitution, nevertheless, has been seen, over the course of the last 150 years of this country, seen to be a relatively immoral enterprise. Even though there's a really large contingent of people who look at it as work, the way labor is looked at as work, and therefore is a totally legitimate way to carry on a living. And that's fine. That's one opinion versus the other opinion. So even though prostitution is not illegal, if in your house, if somebody next door was carrying on sex work in their house, and so like every half hour a new car was driving up to the driveway kind of thing, knocking on the door kind of thing, coming and going all the time, and you knew that's what was being carried on, then you may very well be upset with it, and as a function of that, basically seek to get either sue them for a public nuisance or get a common nuisance charge laid under the criminal code, right? So that's a very old anachronistic use of property that, again, and as time goes on, becomes less and less immoral in a lot of people's eyes, but is still seen as a nuisance from a common law perspective. All right. The second category of public nuisance is the widespread interference with the use of enjoyment of private land. All right. And this basically means that the public nuisance arises when the defendant's activities create what's called a multiplicity of private nuisances. So this is where somebody carries on a lot of activities to such a degree that it almost becomes public, as in it becomes an interference with a number of people's enjoyment of property, but not necessarily on public lands like highways and rivers and what have you, right? So what happens is that this combination of public nuisances private nuisances becomes public when they affect a class of persons or a neighborhood. So if somebody was doing something that was so troublesome that it affected everybody in a neighborhood kind of thing, then these public nuisances, these private ones, would rise to the level of being public in that regard. All right. Examples are things, for instance, like a quarry, where you're mining sand and gravel or what have you, could cause enough dust and noise and vibration to affect a lot of landowners around the quarry. Right. So again, it's rising to the level of being public, even though it's on private land. All right. Okay, guys. So that is negligence. So we're going to deal tonight now. So that was nuisance. We're going to deal tonight with negligence. So give me about 30 seconds. I'm going to get another glass of water, and then we'll start this part of the lecture. right, guys, thanks. Yeah, okay, so it's 10 after 8. I'm not going to keep you a long time tonight. It's really hot and sticky. I don't know if everybody's comfortable or not. So we may not get through all of negligence, but we'll see how it goes. But I don't anticipate going much more than another 30, 35 minutes, and then move into the breakout session. All right, so negligence. Negligence is the most common tort that exists. You know, again, there's lots of torts. Nuisance is one, trespass is one, assault and battery, not the criminal kind, you know, are torts. Libel and defamation are torts. You know, there's all kinds of torts that have been around for a long time. Negligence, however, is the most common one. It's the one that it doesn't require a level of fault for it to take place. It's almost always carelessness. It didn't exist up until about 150 years ago, so there was no negligence. There was only intentional torts, which are all the ones I just talked about, that existed up until about the 1880s, when there was a fundamental shift in legal thinking with respect to injuries to people on the job. And this meant injuries to people both in coal mines, and we touched upon this in a previous class, and on railways. So those two kinds of enterprises were exceptionally dangerous, and people were getting hurt, you know, at them all the time. Basically, this is not just here, but in the U.S. and Great Britain, you know, industrialized countries. And the problem with it is that so many people were being hurt by these injuries, and they weren't intentional injuries. I mean, they were almost always caused by accidents. You know, people don't get hurt, you know, at work as a function of somebody intentionally hurting them for the most part. Something goes wrong, they fall off a ladder, or they're knocked sideways into a machine, or any number of things. So it's an accident. And up until the 1880s, there was no recourse for anybody if they were hurt by way of an accident, which meant that you had thousands and thousands of workers who had lost their jobs because they couldn't work any longer. They had no recourse to any kinds of funds. So what they started doing is suing, you know, the owners of the railways, the owners of the mines. And it became, again, it's a shift in legal thinking. So, you know, hundreds and thousands of lawsuits started being generated, which became a real problem for the owners of all these enterprises because it was taking away from their business. So what happened over the course of 10, 20 years is that, you know, these mine owners, these railway barons, complained to the government. And you got to remember, they were very wealthy people. And so they tended to probably have really good connections with the governments of the day, again, in the US, here in Great Britain. And they basically said, look, you've got to do something to help these people because, you know, we're not going to pay them when they're not working, but, you know, they're suing us. And, you know, we're spending all our time and energy fighting these lawsuits that, you know, we'd rather be spending our time making money. And so what happened is over the course of the next 10 or 20 years is that all those jurisdictions where these things were happening in developed workers' compensation, right? So workers' compensation was a alternate to being sued. So if you have a workers' compensation claim, you agree that you're not going to sue your employer, and, you know, you get paid according to whatever benefits the legislation that's put in place provides you. And that was totally a function of the law of negligence taking hold with people suing because of accidents. And then, you know, apart from workers' compensation, the law of negligence continued to evolve for other kinds of cases that weren't covered by statutory authority. So, you know, things like automobile accidents weren't covered by no-fault insurance for a very long period of time, those kind of things, right? So negligence is a very common tort. And these things you see on the screen, these are the principles of negligence that we're going to go through, okay, individually, just so you understand it. So, you know, the tort of negligence is composed of a number of elements, most of which must be proved by the plaintiff being the person who's been injured, suing the defendant, right? The negligent act, whatever took place that was careless, is determined by what's called the standard of care as it's applied to the facts of the situation. And we'll talk a lot about what the standard of care is, right? There has to be causation, which means there has to be a link between whatever the defendant did wrong that caused the injury to the plaintiff. The damage has to be significant in that there has to be harm caused. So just because there's an accident that takes place that, you know, somebody obviously didn't mean to do. If it didn't cause anybody injury, then obviously there's not going to be any claim for negligence for that purpose, basically. But defendants aren't responsible for every consequence of every negligent act they do. So there's a number of devices at law that are put in place to set boundaries around the law of negligence. Who can sue whom for what, basically. All right. The two most critical devices in negligence law that set those parameters are what's called the duty of care and the remoteness of damage. Okay. Negligence liability cannot be established unless a judge recognizes that a plaintiff owes a duty of care to the defendant, a duty of care being a closeness in the relationship. So here's where remoteness of damage plays a role. So a negligent act may be an utterly improbable consequence of what is done by the plaintiff, the defendant, and therefore is not going to be negligent, right? So the court may well hold that the consequences of somebody's negligent activity may be too remote to be compensable by the defendant. So the court determines that by looking at, again, the duty of care and the remoteness of damage. The framework for negligence is what's considered to be a fault-based civil liability system. That's the tort system that's developed at common law we have in Canada, basically. Negligence law is a loss shifting system. Loss meaning the person who has been injured, who sustains a loss, being the plaintiff, they shift that loss to the defendant to compensate them for the damage caused. So it shifts the loss, and it's based upon imperatives of individual liability. All right. Predominantly, negligence in the real world, the shift in loss is now handled almost always by insurance, right? So there's very, very few things that that people, how they're injured, that they can't turn to some kind of insurer to pay them for the injury, right? So it doesn't shift the loss directly onto a defendant any longer. It shifts it onto the defendant's insurance company, right? So the standard of care. So the standard of care is what level of carefulness does somebody have to be when they have a duty of care to make sure they don't cause somebody damage, right? So it's the failure, if you've fallen below the standard of care, it's a failure to take care for the safety of the person that you're obliged to take care of, right? And the common law has resorted to what's called the reasonable person test, right? Which is a normative standard. What level of care would a reasonable person have to take in dealing with somebody else, right? So it's a reasonable, careful person in the circumstances of the defendant, right? It's an objective standard. Reasonableness is almost always an objective standard. It's not subjective, it's objective. It focuses on the defendant's conduct. That's the person who's caused the injury, and it's reference to how that conduct compares to what a reasonable person in the same circumstances would have done, right? So no thought is given to the defendant's thought processes or their subjective mind, right? So it's not like criminal law where there's mens rea. That doesn't apply in the law of negligence, right? So, and the test of a reasonable person excludes all physiological and physical traits that makes each person different. So again, back to the objective standard of a reasonable person, right? But that doesn't mean it's the average person, right? Average people aren't always reasonable people. So that's not the test. It's not what the average person would do in a circumstances that cause injury. It's what the objective reasonable person would do, all right? It's not a standard of perfection. So the courts over time have recognized that people can be negligent, obviously careless, but in some circumstances, the carelessness is excused, right? It depends upon again, the reasonable person test, right? So the application of the standard of care, right? So the standard of care is applied to the facts of the situation. Courts have used a number of factors that guide what a reasonable person would do. This is the test they use. And so the most significant test they use is what's called the reasonable foreseeability test, right? So the central element of that is that the standard of reasonable care is the concept of reasonably foreseeable risk, right? The reasonable person, reasonably careful person avoids creating a foreseeable risk of injury to others. So it's a risk analysis. If I'm doing something with you and I have a duty to be careful to you, we'll talk about duty of care in a second, but if I have a duty to be careful to you, right, then I need to foresee things that I do to interact with you that I can foresee would or would not cause damage. So I have to be able to reasonably foresee elements of risk that I would avoid as to cause damage, all right? So Gloucester versus Toronto Electric Light, now Toronto Hydro. So a boy, 8.5 years old, was injured when he reached out and touched a live wire that was just 14 to 20 inches, so half a meter, away from a public bridge in which he was standing. The danger was obvious to a reasonable person, and it would be to any of you. So if you were in a public area like your outdoors and there's a public bridge and you see a live wire, dangling from some part of that bridge, it's reasonably objective to assume that that is, that's not a foreseeable risk that anybody would accept, right? There have been other cases where children have been electrocuted and not resulted in liability, but that totally depends again upon the circumstances of the cases. The highly discretionary nature of what's reasonable and what's not provides a great deal of freedom for judges and juries when they deal with it, basically, and that's the essence of negligence. How far does somebody have to go wrong to be found liable, right? Consideration is given not only to the foreseeability of damage, but also to the likelihood of damage being caused. So a reasonable person would take greater care when there is a stronger likelihood of damage taking place than when, that same level of care would cause minimal damage, right? And the leading case is what's called Bolton and Stone. This is a British case because it deals with cricket, right? So, and it's about 80 years old. So the plaintiff, this is somebody standing on a street outside of a cricket pitch, was struck by a cricket ball, right? So she was standing outside the street, just outside her house, but there was a cricket pitch or whatever they're called next door. So the ball was hit out of the cricket ground in the course of a match, and it hit her. And they're wooden, they're hard, right? And so it would cause a fair bit of injury to her, right? And the facts of the situation were that in the past 30 years, approximately 6 balls have been hit out onto the street. So like 1 every 5 years kind of thing, okay? And the court in that case found no liability. They basically said that, to demand that kind of reasonable foreseeability of risk is unreasonable because it would be excessively burdensome to ensure that no balls would ever go outside the cricket match at any time, really, as opposed to 1 every 5 or 6 years. So that those are circumstances where, in fact, there was no liability. So the court drew a distinction between reasonable, foreseeable, reasonable risks that are substantial and material, and those risks that are highly unlikely or mere possibilities. And again, that cricket ball going outside once every 5 or 6 years really is or was seen as a mere possibility. A reasonable person will also regulate their conduct with reference to the severity of the harm. This is the severity of the person who's injured. So in this case, right, Paris versus Stepney Borough Council, the plaintiff, in the course of his employment, was removing bolts from the chassis of a vehicle with a steel hammer. And although the plaintiff had previously lost sight in his one eye, right, so he was blind in one eye, his employer did not give him protective eyewear, while he was working at his job. So while he was carrying out that task, the hammer onto the steel, a splinter entered his good eye, right, and he became totally blind. These are really terrible fact situations, but they're absolutely true. So the defendant employer argued that because the risk of an eye injury was relatively low, and it's probably true that it's not that often when somebody's banging a hammer on a chassis of a car that a splinter would enter somebody's eye. It's pretty remote for the most part. The employer argued that because the risk was low and because it was not customary at the time, this is now a long time ago, it was not customary to provide protective eyewear to fully sighted somebody with 2 eyes, employees. it was unnecessary to provide protective eyewear to the plaintiff who only had one good eye. That was the argument that the defendant took, basically. They argued that his risk of an eye injury was no greater than that of any of their workers. And that's true. The possibility of it happening was no greater, right? So while there may not have been any greater risk of injury, there certainly was a greater risk of injury to him, as in, losing one eye would make him totally blind, right? So the court found that a reasonable employer, again, that word reasonable, would have taken greater care for an employee who had already lost his sight in one eye, right? So that was the case that found that the amount of injury that could possibly happen to somebody elevates the care that has to be taken by a reasonable person, right? Some consideration is given to the magnitude of the risk, right? The likelihood of the damage multiplied by the seriousness of the harm. So those two things must be balanced with respect to the cost of the measures needed to reduce or neutralize that risk. So this is a very practical assessment of those two issues. So where reasonable, affordable, and practical safety measures are available to combat reasonable risks, they must normally be taken. It was perfectly in the case of the lost eye, a reasonable, affordable, and practical safety measure would have been providing goggles, right? This makes sense, even if they weren't common safety items in those times. In Ware's Taxi versus Gillihan, the defendant taxi company transported young children to and from school in a four-door car. In the course of the journey, the plaintiff, a little 5-year-old girl, was playing with the push-button lock on the back door. The driver told her to stop doing that. You can imagine that's exactly what happened. Nevertheless, the door opened, she fell out onto the street and was severely injured. Basically, the court noted that the cost of child-proof locks would have been available for the cost of $10 per lock, right? So that would have been certainly reasonably affordable. The utility of the defendant's conduct is also relevant with respect to the application of the standard of care, okay? So those cases not involving governmental services where the inevitable price of direct and necessary benefits to the public provides a risk, then there will be no liability. Utility, and that's basically what they're saying is the government, who is paid for by taxpayers, when they undertake tasks on behalf of the public, then they will be given a free pass to some degree with respect to any damage they may well cause, right? Causation is important. So again, somebody can be negligent, but in order for them to be proven to be liable for negligence, their activities must be proven to have a direct relationship to the injury caused. So the injury has to be caused by the defendant. It's caused, the test is called the cause in fact, which basically is referred to as the but-for test. So again, this is a very old test at common law, but still exists in all common law jurisdictions today. And the test is this. The question is asked, would the plaintiff's damage, right, the person who is hurt, would that damage have occurred but for the negligence of the defendant? Okay, it's a pretty straightforward test. So if the answer is no, the defendant's negligence is a cause and fact of the damage, right? So if the answer is no, meaning that the damage would not have been caused but for the actions of the defendant, then the plaintiff wouldn't have been injured. So there's going to be liability there. If the answer is yes, though, is that the damage would have occurred whether or not the defendant was negligent, then there's no cause in fact and therefore no liability, right? It's not necessary to prove that the defendant's negligence was the sole cause or even the predominant cause of the damage. So for instance, somebody has a gun and they shoot somebody across the room with that gun. It was careless. We're talking negligence here, so they didn't do it on purpose, but they shot them, and they shot them in the chest shoulder area. So they're rushed to the hospital and they undergo surgery. And in the normal course of events, this isn't a life-threatening injury, right, in the shoulder. That's where everybody gets shot on TV, right, in the shoulder, so they don't usually die. But in this case, the surgeon is maybe inebriated or had an argument with his or her spouse, or was lost money in the stock market that day. For whatever reason, the surgeon is incredibly negligent, and the person dies. Okay, so the question is, the person who actually shot the person who passed away, but for the actions of that person, would the other person who was shot actually die, right? And the question is, no, not really, not but for their actions would they die, but for their actions, the person would have been shot. So, you know, so even though they didn't cause the death, they would still be liable for that death to some degree, certainly the initial injury, but so would the surgeon, right? The surgeon would also be liable. So there would be a combination of contributory negligence between the person with the gun and the surgeon causing that kind of injury, right? So that's where negligence law basically apportions damage. Okay, duty of care. So duty of care is incredibly important because nobody is going to be liable in negligence if there's no duty of care between the parties. So if you are a next door neighbor, and again, you know, you have something that emanates from your property that causes environmental harm to your neighbor, right? You pretty much have a duty of care to your neighbor not to do that, right? Most neighbors expect their, you know, next door neighbors to take care as to not cause them harm. So there is a duty of care. Interesting, just so you know, doctors, if they're walking, say a doctor is walking along the street and somebody is on the sidewalk and they're injured, right? Doctors have no duty of care to take care of that person, right? Unless the jurisdiction they're in has a Good Samaritan law that basically puts in place a legislative duty to do that kind of thing. We don't do that in Ontario. We don't have, or in Canada for the most part, we don't have Good Samaritan laws. So again, somebody's injured on the street, a doctor who certainly has the skill set to help them has no duty of care to stop and help them. That's just the common law. However, if the doctor does stop and bends down to treat the person who is injured, that creates a duty of care, right? That creates the proximity between the two parties where now the person who's injured should expect the doctor who's attending to them to take care of them carefully, right? So once the duty of care becomes a reality with the doctor bending over, then the law of negligence kicks in. And so for instance, once that duty of care exists, then that doctor has a standard of care to take care of the person as any reasonably foreseeable doctor would take care of them, right? That's the whole thing about negligence, right? The most famous case about duty of care is this one. It's called Donahue and Stevenson, 1932, the English House of Lords. So what happens is Mrs. Donahue and her friend go into a public house in Great Britain. The landlord or the barkeep, the owner of the pub, is a guy named Stevenson, right? So Mrs. Donahue and her friend go into the pub, and her friend goes up to the counter at the pub and buys 2 ginger beers, which is an alcoholic beverage. You can buy it at the LCBO. Buys 2 ginger beers for herself and her friend, Mrs. Donahue. So they're sitting down and they're having the ginger beer and what have you. And before Mrs. Donahue finishes her beer, she looks inside and she sees there's something inside of it. So she has a saucer. She pours out the balance of her beer, and there's a decayed snail in it, a half-decayed snail, meaning she probably ingested the other part of the snail. And as a function of that, she gets violently sick. Shivani, I see your hand. I'll call you in a second, right? So she's violently sick. So she sues Mr. Stevenson, the owner of the pub, for that, you know, for her illness, right? She thinks that she has a decent case in that regard. And the House of Lords said no. There was no duty of care between Mr. Stevenson, the pub owner, and Mrs. Donahue. And the reason there wasn't a duty of care is because she didn't buy anything from him, right? He had no obligation to her just sitting in his pub. You know, there was a duty of care certainly to Mrs. Donahue's friend who bought the ginger beer. That duty of care was created when she went to the counter and bought the beers, right, between her and Stevenson. But there was no, it's called privity between the pub owner and Mrs. Donahue, all right? Now, this case is really famous because while it found negligence, you know, that there was no duty of care is a different story in contract. Shivani, you had your hand up?
Oh yeah, I was just gonna contribute that the common law established the neighbor principle in Donahue and Stevenson.
That's right. Absolutely true. It's the good neighbor principle, right? There's a very bit of that in your
Yeah.
text. Good. Okay. So here's what I'm just going to go through this. Here's what Lord Atkins said in the case. So this is Donahue and Stevenson. The rule that you are to love your neighbor becomes in law. You must not injure your neighbor. And the lawyer's question, who is my neighbor, receives a restricted reply. You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Who then in law is my neighbor? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question, which is basically a synopsis of the law of negligence, right? There is the notion of a close and direct relationship, which is captured by the word proximities, proximity being privity, used in Lord Atkins' judgment, and again, the idea of contemplation of foreseeability of damage to the plaintiff. Okay, so that's elementary so there has to be that duty of care, all right? And again, as Shivani was saying, that's the neighbor principle that requires the foreseeability of harm to the plaintiff as the primary touchstone of the duty of care. Okay, duty of care is the primary instrument of control over the extent of negligence liability. As a function of that, consideration must be given to public policy and whether or not the recognition of a legal obligation to exercise care in favor of the plaintiff is in the best interest of society. So this is how negligence is shaped by societal norms, which change over time, right? And you know what? I'm going to stop there. We won't necessarily go through the defenses. I leave these for you to go through on your own. There's 4 separate defenses there, so please look through the PowerPoint to see what the defenses to negligence are. They're pretty straightforward in the points here. Again, with respect to remedies, the remedies at negligence are almost always damages, right? Because it's not negligence and carelessness isn't something you can foresee, so you're not going to be seeking an injunction for it, right? You are going to be seeking damages for the harm that's been caused. All right, any questions about the lecture tonight? All right, so we'll stop there. So let's go to the breakout sessions. So again,